back to the show. This is The Law Show on CL 650.
And welcome back to The Law Show on CL 650. Joining us in studio, the two Joes, Joe Battista and Joe Murphy of MurphyBattista in downtown Vancouver. And we're talking about power of attorney. Now, I know this because I've done a couple of wills with my wife, and we have talked about power of attorney. But you're saying that's only one level of impact that can be in your life. That's more the financial, the ability to run your finances, but there are other layers to that. So go through that again for us.
Okay, you're right, Zach. A power of attorney is a tool primarily for financial matters and business matters. Healthcare decisions and healthcare consent requires either a representation agreement or a comiteeship. So
the reason I bring it up is because I know in my personal will, I just have this general power of attorney. Do you think most people just have that, or do they think when they have their will made up, all of these other elements are included?
Okay, I don't know that there's a power of attorney in your will.
Right.
A power of attorney is a separate
item. Yes. I'm just saying when we had it done, we had the power of attorney done at the same time.
I see.
So do most people just generally classify all of these things as power of attorney? Is that sort of the colloquial way of talking about it?
My experience is that most powers of attorney are general for everything.
Right, okay.
So it doesn't limit it. It can be for a very specific purpose, but especially in a spousal situation, you want your spouse to be able to carry on with things and not really limit him or her in what they can do. So they create a general power of attorney. The other thing you can do is that you can put a clause in the power of attorney that says that it will continue in effect in the event that you become mentally incapacitated. If you don't put that clause in, a power of attorney becomes void upon your becoming mentally incapacitated. Again, most people put that clause in because they want to cover off that eventuality.
Because you might have a sudden situation where you're disabled, you have a stroke or a car accident, and you have a brain injury. So that's when you have this other part of it.
Exactly. A power of attorney and a representation agreement requires some type of mental capacity to sign these documents. If you haven't done that in advance and something catastrophic happens, such as a stroke, a car accident that causes a brain injury where you were incapacitated, you don't have the power, the ability at that time to do a power of attorney. I have a lot of people say, my husband, he doesn't recognize me or anything, but he can sign his name. Can you come and do a power of attorney? Well, the answer is no, because it's not the act of signing your name. It's the act of knowing what you're signing and the power that you're giving someone. It's too late at that point. The power of attorney doesn't do you any good. And it falls back on what's called a comiteeship under the Patient's Property Act. And the disadvantage of that is that it's time-consuming to do. It requires a court order. It's more expensive.
So this is after the fact, after somebody's had a sudden injury or something. Yeah.
Had a sudden injury and they don't have a power of attorney or they don't have a representation agreement, but you need some mechanism so that someone else can carry on their business affairs and make decisions for them. So it falls back on having a committee appointed. Under
what is the process for that?
The process, it requires two doctors to certify that this person is incapable of managing himself or herself and their affairs. You get those affidavits, those opinions. You start a court petition. You go to Supreme Court. Sometimes you have to serve family members. You have to serve the Public Guardian Trustee's office. And then you go in front of a judge, and the judge decides whether or not they will make the order. Typically, it's rarely not made, but you do need two medical affidavits that says that the person's incapable.
Now, I could see there be some gray area, obviously, where people maybe are have mental instability, or maybe they're a drug addict, something like that. So maybe at some point they're not capable of looking after themselves, and then they become capable.
That's the tricky part. You can reverse a comiteeship. I think Joe and I have had some happy cases where our clients we had committees in place, and then with the passage of time over many years, they have improved to the point where you can reverse the comiteeship. And I think Joe and I have each had 2 or 3 of those clients that are are happy stories where they've improved to the point. But
are those brain injury cases?
Yes, typically they're brain injury cases. But sometimes if someone has a psychiatric illness where they're functioning well when they're on their medication, they go off their medication and they can't function at all. You've got no control over that. They seem to, go back and forth between being capable and being incapable, and it becomes untenable to keep going to court each time to reverse it back and forth. So that's a tricky situation. When it comes to cometiships, sometimes it's very obvious. You have a brain aneurysm, the person's in a coma. There's no question, it's obvious. It's a little trickier when, say, someone is suffering from a dementia. It's a progressive disease. And you're wondering, is it at the point where they're no longer incapable? Because typically you have to serve that person. That person can challenge it and say, look, I don't think I'm incapable, and get evidence to rebut it. So when it's gradual, typically it's a spouse or children that have, I'm concerned about mom or dad. He's starting to tip the paper boy $100 when he pays his bill, or thing. You sort of see little things, and then it becomes this fight in court over whether or not mom or dad or someone else is incapable.
What about a child who's mentally disabled since birth, and obviously the child is the parents are the guardian, and then when they become 18, so do you have to apply for it then? Yes,
it's actually 19 in British Columbia.
Okay.
Alberta and Quebec is 18, but it's 19 in British Columbia. Yes, if it's necessary. If your child is living at home and doesn't have any real assets to administer, it might not be necessary, but it would be for healthcare decisions. So you may want to get it for that reason. A cometiship can deal with two things: financial decisions and healthcare decisions. And it doesn't have to be both. You can be incapable of one and not the other, or incapable of both. But you specify when you apply to court if you want it, the order in respect of both the finances and the person and healthcare decisions.
Now, in your line of work, and you have people who obviously, we've had Joe on many times talking about brain injuries. Have you had situations where people don't have the right setup for their power of attorney?
Many times.
Well, it's normal that they come to the office, the family does, and there is no power of attorney. There is no representation agreement. Because these are usually young people, often 19, 20, 21, who are in these accidents. So nothing's been done, and they're incapable, initially in a coma. But it becomes more difficult, Zach, when they come out of the coma and they begin improving, to decide whether they're capable of functioning or incapable. And people with brain injuries can become very vulnerable to being manipulated by others. They become very overly trusting sometimes. So it's that vulnerability that creates the need for something, for a safety net. And the cometiship, the court order, provides that safety net, because when a cometee is appointed, it means the person loses all their right to make any kind of financial decisions. So if a court has said I can't manage my affairs and it's going to be my brother who does it, I can't go down the street and buy a new cell phone and sign the contract for it.
Right.
I don't have the legal authority.
Yeah.
So it's a real safety net. No. But you get people who can appear to function quite well, but in fact they don't function very well, and that's the tough situation.
Now, we'll turn this on its head, because you brought up a good point, Joe, about a young person having a brain injury, for example. So we're talking about power of attorney for maybe elderly parents, and you're going to be able to make decisions for them when they become maybe mentally unfit to do so. Now, should you have this same sort of setup for your children once they're past 19? Or do you need that as a parent? If your child was, say, snowboarding and banged their head and they couldn't make decisions for themselves, do you have to go through this process, even though you're a parent?
I may be a bad parent. My son doesn't have a power of attorney or a representation agreement. Of course, it would be, ultimately it may be useful, but I don't think parents think of it for their young children. I think it's more you want the person themselves to make that decision when they're married. They may have children they have to worry about. If your children are single, and you can go on, you can pay the bills if they don't have a lot of legal obligations. But once you become married and have your own family or a business, then it becomes more important. And I would like to think that at that point, children would make their own decisions to do it. But I don't know that it's necessary to rush off for a 21-year-old or a 20-year-old to get them to do a power of attorney representation agreement at that point if there's no other compelling reason for it to be done.
I think, Zach, the logical time to do it would be when you're making a will. Mm-hmm. And if you're married,
typically when you're married and kids, and
have children, you need a will. So it's part of the package that should be done at that time.
How many of your clients come in and don't even have a will? Do you see that often?
We don't ask when a new client comes in if they have a will. I don't know, half, I'm guessing.
Yeah, quite a few. I know don't have a will. I think it's one of those things where it's cultural. I know some cultures just don't believe in wills, that, you know.
You don't plan for your death?
You don't plan for your death, and my family will work this out.
We've seen how that works out.
Yeah, and yeah, you're right. But I'm afraid there's a lot of people that don't have wills. I couldn't put a percentage on it, but there are a lot.
I guess there you have sort of personalities where people who have plenty of insurance and they have their will and they have their power of attorney all set up, and they're that kind of personality. And then you have the other side where people, that's not going to happen to me. I'll be fine. Yeah. I'm sure you see those personalities. Yeah. Yeah.
You know, Zach, you asked me about a power of attorney for children. The one thing that I did stress on my children is to be properly insured on their cars.
Yeah.
If there's any advice you can give your children in that genre of advice, be sure that they're adequately insured.
So take the $5 million liability.
At least, yes, take the $5 million for sure. Because you don't buy insurance hoping you're going to use it. You buy insurance to protect you if you need it, and that is the one thing that I was quite insistent about. But it's a little different than what you asked me. But
that's good advice. Yeah. We're getting it straight from the people who deal in these situations where you need the insurance. And then the other one is to a lot of young people renting their first apartment don't think about having insurance for their contents or any liability, like having a dog, as we spoke about in the first part, is to, because I think tenant insurance in an apartment is dirt cheap. There's nothing to it really.
I can remember when I first bought my policy, it was either $12 or $18 a year.
I think my first one was $35.
And now I think they're about $200 and change. I think.
Yeah, but that's a lot of money for somebody coming out of university, right?
Yep.
Yeah, it is.
All right. Well, it's been a very interesting conversation. Our guests this week have been Joe Murphy, QC at MurphyBattista, and Joe Battista, also QC at MurphyBattista. Having the two partners here in studio doesn't happen very often. It's been a few years, so it's been great to have you both in studio, and we'll have another conversation on a future show. This is The Law Show. I'm Zach Spencer. Thanks for listening to CL 650.